following program is classified G. It's suitable for all ages.
Tonight, do you feel safe when online? Do you feel as if our laws have caught up to help protect us from the crimes and cons in cyberspace? In the recent past, our lawmakers and authorities have taken an increasingly strong stance on fighting crimes online, where multiple organizations were set up to collect complaints and retrieve information pertaining to cyber offences, given its volatile nature. With technological advancing at an alarming pace, has our country's laws managed to address loopholes used by criminals to exploit you and me and stay hidden from the law? Can the law reach out to find justice for crimes committed against Sri Lankans in countries far away? Welcome to Law, Land and Liberty, where we bring to you a contemporary legal topic and break it down in the midst of an expert within that field. And this week we selected cybercrime in industry, an issue that has been dwelling for quite some time, but the legal aspect of it has been in a vacuum, one would say, a bit of a grey area, and we need to really shed some light into it. And as usual, our guest is someone who is a big figure within this field and who has really pioneered, and I believe he was the first author of the first IT law textbook within this country. Dr. Sunil Abeyratne is joining us today. Thank you so much, Doctor, for joining us. In breaking down the entire discussion, we are going to look at the topic in four key areas. Firstly, the cyber law within the country, the basic provisions. Next, the laws governing online activity in the country. Next, afterwards, crimes related to e-commerce within Sri Lanka. And then international crimes related to cyberspace.
Hello, my name is Sunil Abeyratne and I'm an economics student. My question is regarding the Computer Crimes Act number 24 of 2007. What are the provisions taken by Sri Lanka to curb cybercrime?
All right, let's go into the discussion. Firstly, on the cyber law within the country. Doctor, let's break this topic down firstly and start from the first point itself. It is the fundamental law that governs the cyberspace, and when it comes to cybercrime within this country. And many would refer to the Computer Crimes Act, which is the common legislature. But are there any other legislation? Can we just get a beginning there, Doctor, and really get a breakdown from that point onwards?
Any jurisdiction we can see criminal justice system and civil justice system. Now, under criminal justice system that we have experienced, there are a number of areas. Now, when you look at our history, criminal justice system in Sri Lanka, basically we have the penal code. In addition to the penal code, time to time the legislature introduced the number of statutes relevant to criminal activities, comes under criminal justice system. Now, we can see a development of computers and network in the world. Then all jurisdictions realized, without modifying the existing penal code provisions or other provisions relevant to criminal law, especially in Sri Lanka, when you look at, we can see the penal code. Like other countries, they also have their similar provisions. Without modifying or without introducing new provisions to their criminal justice system, it is not easy to deal with computer-based offences, considering nature and behavior of data and especially communication, electronic communication. Mm-hmm. So as a result, mainly that when you take European Union and United States and other developed countries, time to time they introduce various new criminal offences to the system. Mm-hmm. Now take example in United Kingdom, now they have Computer Misuse Act. In 1990 they introduced that act. Now based on that act, Sri Lanka also followed that Computer Misuse Act in the United Kingdom, and we introduced Computer Crime Act in Sri Lanka in 2007. This is the history. There's a reason behind that to introduce this new legal provision. Simply, now take example, if a person steals data from a computer or a system, you may feel that we can deal that issue applying the offense of theft. But you can't apply the penal code offense, the theft, because data is not tangible. That data is not a movable property. Now, take another example. When you take hacking, what is hacking? It is unlawful entry. Unlawful entry. The person will obtain unauthorized access. Now, when you look at penal code, we can find some similar sections. This criminal trespass.
Trespassing, yeah.
But you can't apply criminal trespass to deal with computer hacking or cracking. The reason is here that you are not entering into another's property physically.
True.
So likewise, there are lots of difficulties you would face if you are going to apply the existing provisions under criminal justice systems to deal with computer-based offences. So this is the birth of Computer Crime Act.
If ironing out a few issues on the offset itself, Dr. Property, things like things like data, how are they identified in the current law? Now, you did mention when as you began that there is an issue with certain vacuums in the penal code. Let's discuss those provisions as well. But is property now trespassing or hacking is a severe issue, and like the world is facing this issue as well. Do we have no legislature that looks into it, or is it still in the evolutionary stages?
In Sri Lanka, when you look at the Computer Crime Act, we have covered most of the provisions relevant to computer-based offences. Especially when you look at Section 3 of Computer Crime Act, it says if a person obtain unauthorized access to a computer system. Then if a person obtain unauthorized access to commit further criminal offence, it comes under Section 4. If a person modified, then the data also comes under that. If a person change information inside computer system, it's an offence because this is unauthorized access. It's an offence under Section 5 of Computer Crime Act. We can find similar provisions under Section 3 of Computer Misuse Act in United Kingdom 1990.
So what you significantly mentioned is that we have sort of taken a motivation or taken the inspiration from the United Kingdom when it comes to enabling legislature within this country. Which core areas do you believe within our first segment? Let's just clarify this, Doctor. When we take the Computer Crimes Act, are there any other subsequent acts that we should understand in reference to this when moving forward? Because hand in hand, what goes with this issue of computer crime is the freedom of expression. Things like that are also very much bound here. And issues of privacy, number of human rights issues get entangled when we talk about computer crimes. So, are there any other legislation that we should really bear in mind? And are there provisions in the Constitution pertaining to computer crimes, or is that not something that we have gone to so far?
When you take Computer Crime Act, we can't interpret provisions in an isolated manner.
Okay.
Now, at the time of drafting Computer Crime Act, the Budapest Convention was in operation.
Okay.
From 2001, Cybercrime Convention, Budapest Convention was in operation. But we didn't follow Budapest Convention at the time of drafting this Computer Crime Act. We followed basically Computer Misuse Act in the United Kingdom and provisions available in other countries. Recently, we accepted and ratified Cybercrime Convention, Budapest Convention.
Okay.
Now, when you look at Budapest Convention, the number of key areas have been covered. As you said, privacy policies, data protection, there are criminal offences relating to intellectual property. So likewise, the offences relating to children, all covered. Now it's a high time that we have to look into that. We have to revisit this act, and because it's an international obligation now. True. Since we have accepted the ratified Cybercrime Convention. Now it's high time to bring some new offences following Cybercrime Convention into our Computer Crime Act.
Okay. Again, Dr. as we conclude the first segment, I want to ask you the next question on authorities. Now, people, when it comes to an issue in their domestic lives, they would know the authorities. They would say either the police, they would say either they have to go to the judge, and it's not uncommon to hear about what needs to happen. But when it comes to computer crimes, people hear of the CERT, people again understand that there's a division within the police, but what are the authorities? Where do we go to in the event we have a complaint to make?
Basically, police department is the main authority to investigate cybercrime, but they have set up a separate cybercrime unit attached to the criminal investigation department. CERT is there to assist for investigation, because they will not file cases against any wrongdoers. They are there to assist. Mainly, they will assist the government, or if the police ask for assistance from CERT, even private party, if they ask for assistance, they will provide. Otherwise, that CERT will not go for the prosecution. Prosecution will be done by the police.
All right. Doctor, feel free to continue on those lines, Doctor. I want to ask you now, again, when it comes to a normal criminal offense, we can easily identify the elements of a crime. One would say even gathering evidence is not alien to people. But when it comes to the cyberspace, evidence and things that are common in other criminal offences become a bit difficult to pin down. How are those things identified or understood within maybe the legislature we currently have, the Computer Crimes Act, or are there areas that we need to evolve in?
This is another science. Now, the world is developing, technology is developing. As a branch of technology, information and communication technology is also developing. Now, nothing is impossible. So, when this science and technology is developing, there are some people who try to misuse this development. So you can't stop it.
Yeah.
So that we have to develop new methodology to seize and preserve and to produce evidence before court. As you said, we will enter into another area. There's a question arise: can you apply the existing legal provisions relevant to admissibility of evidence for electronic evidence, considering its nature and behavior mainly?
Yeah.
So this is the question. For that also, that international community, the time to time, they introduce various solutions. So following this international experience, Sri Lanka also introduced the first act in 1995, Act number 14 of 1995, Evidence Special Provisions Act. When you look at provisions under Evidence Special Provisions Act, it is enough for computers available during that period.
True.
Now we are using lots of high-tech devices and lots of new networks are available. Considering that, even the United Nations also considered the situation. They introduced, firstly they introduced UNCITRAL, United Nations Commission of Trade Law, introduced a model law on electronic commerce, the electronic signatures. Following these two model laws, in Sri Lanka we introduced Electronic Transactions Act in 2006. Now, in 2005, United Nations introduced a convention on international electronic contracts, mainly for electronic commerce, based on electronic commerce and international electronic contracts. Following this convention, Sri Lanka, we must be proud that we are one of the 2 countries entered into this convention from Asia. We accepted this United Nations convention, so that we have already ratified. That means we have an international obligation to follow this convention. Based on that, our Parliament brought an amendment to E-Transactions Act in 2017, Act number 25 of 2017. So this is the situation at the moment in the country.
All right, very good start there, Doctor. A lot of things we need to clarify per into a number of key areas. Let's take a very short break. You're with Law, Land and Liberty. Stay with us.
And I'm a law student. My question is to do with laws governing online activity. How is online activity governed under Sri Lankan law?
Welcome back to Law, Land and Liberty. We are in conversation with Dr. Sunil Abeyratne. Doctor, let's take a step further now into the cyberspace and online activity. Something that you have wanted to touch on is the frauds that happen online, and I want to make this a separate segment and talk about e-commerce separately. But how, like when we think of things like social media, and the internet penetration right now is extremely high, and for like a country like Sri Lanka, we have that sort of accessibility that's going on, and it's a very good thing. But what legislature does, or what exactly is the procedure to govern things like social media, things like the fraud that happens within these platforms?
When you look at criminal offences under Part 1 of Computer Crime Act, we can't see computer fraud as an offence. Certain areas are covered under Section 5 of the Computer Crime Act, under computer modification. But when you look at Cybercrime Convention, the Budapest Convention, this is another that separate area called the computer-based the fraudulent activities. So when you look at computer crime, more than 60 to 65% of the offences come under fraudulent activities. So that means we have to identify what is computer fraud clearly. If we have that separate offence, so that it is easy to investigate and it is easy to bring wrongdoers to the before courts. So this is high time, because since, as I explained you earlier, since we are a member of Budapest Convention, now it's high time to introduce this new criminal offence. And in addition to that, under Intellectual Property Act, we can see the number of offences. We have covered number of criminal offences there as well. In intellectual property relevant to cyberspace. So that is there. I can't see any new offences we need, but anyway, considering the development of these computers and network, very soon that we have to introduce the couple of new offences. And when you come to the second question, the social media.
Yeah.
This is the one area. If we have computer fraud as a separate criminal offence, then we can find that lots of solutions on that. We had criminal defamation prior to 2002. It was an offence, criminal offence under the penal code. In 2002, the then government brought an amendment. They removed that penal offence from our penal code. Now it is not a criminal offence. During that period, that we wanted to protect media personnel who are involved in media. Considering that fact, the government wanted to remove that penal code provision. But anyway, considering the rate, the high criminal rate, the people are misusing social media like Facebook and other social media. Now it's high time to bring either the same offence or the modified provision to cover that area. If there is a direct criminal offence, then we can reduce number of misuse activities based on social media.
All right.
So these are the two areas we have to think about very seriously.
Doctor, in continuing the discussion, I want to get your take more on like this aspect of social media, because you did touch on the fact that social media has a variety of aspects, a variety of variables, one would say, where a lot of people can do a lot of things, but maybe not under that same amount of control. But where does it coincide in terms of legislature? How is the social media governed? Is it governed? And how, if so, what are the basic things that we should know about it?
Now, first of all, we must understand what is social media. The social media means there are a group of people who have common objectives. They get together and they use this platform to exchange their views. So we can't say there is no control. There is a control that depends on the territorial jurisdictions. So that means when you look at laws available in jurisdictions, the jurisdiction to jurisdictions, laws can be different. This is the main issue. When you look at European Union, they consider all member countries as one region. Earlier they had data protection directive. Their privacy policies, data protections are governed under that directive. Later they realized there are some loopholes in these directives. Now the present situation is they maintain GDPR, General Data Protection Regulation. Now following this GDPR, the Sri Lanka also has drafted data protection bill. I don't know that what is the time period, of course I can't exactly say. Anyway, that if the parliament passed that bill with or without amendments, then we also can follow certain provisions available in most of the countries in European Union. The following EU data protection directives, United States, even in Australia, Korea, Malaysia, lots of countries, they have introduced their data protection laws. Now it is very important as far as the behavior of the social media is concerned. Now, there must be controlling mechanism. Now, at the moment in Sri Lanka, the one issue is we don't have proper data protection law or privacy policies. There are some acts, statutes are there. When you look at Computer Crime Act, Part 2 covers certain areas. Even ICPPR Act also, that there are some provisions, but it's not enough as far as electronic communications are concerned. This is one area we have to consider very seriously. The second area is penal provisions. As I explained you earlier, this is high time to introduce some penal provisions to deal with the people who misuse social media. Other countries, they have that mechanism. Now it's again, it's a high time to introduce such provisions also in Sri Lanka. By that, of course, we can control the social media. When you look at Section 6 of Computer Crime Act, this is very serious offense. Most of the people in this country, they are not aware. If a person misuses computer system against national security, national economy or public order, it's a criminal offense under Computer Crime Act. We can't just post that video clips or any pictures to social media. We can't just release. Because Section 6 is very serious offense. Now, it's the duty of that lawmakers have already done that. Now, it comes to the implementation part. Of course, I can't satisfy that our implementation part is very successful, but we have to go a long journey. So at least there must be some prosecutions against people who misuse the social media.
Doctor, I think you come to a very good point there. I want to touch on accountability. Now, people might share something online that they receive and mention, okay, the source is somewhere else. I don't have that same accountability. I don't have it. Like I don't have the responsibility to review what I'm sharing. Is that what the law says also, doctor? Or does when someone shares something or when someone posts something, what is the accountability factor that is given to that individual?
Now, this one issue, this is what I explained earlier. Yeah. Now, how the other countries, they control this mechanism. Now, it is very, we can clearly understand and we can see that how these other countries control, introducing various laws, regulations and rules. Now, one area is, as I explained you earlier, the data protection.
True.
Then even intellectual property. Then to introduce the various criminal offenses, including computer fraud. And another area is defamation. Either we have to, as I explained you earlier, either we have to introduce criminal defamation back, or we have to introduce modified version, protecting that media person, that we can find some mechanism. It doesn't mean that we have to reintroduce the same offense. Yeah. But anyway, there must be some mechanism.
The law should evolve to cater to that. I think this very important point was also mentioned when Senior DIG Ajit Rohan also came here, that there's a vacuum when it comes to considering defamation. A few other things that we need to discuss. Let's talk a bit about the e-commerce aspect. Dr. We'll go in for a break. But before we go in for the break, we have our segment on the legal happenings within this week. Here is Suzanne Shenali with Law in the Land.
Thank you, Danidu. Let's take a look as to how the law has worked in our land. The Civil Appellate High Court of Mount Lavinia has delivered a judgment upholding the prescriptive rights of a person who occupied a disputed property for nearly 40 years. The plaintiff had instituted an action before the Mount Lavinia District Court for his title to be established over a property in dispute through an action by which the plaintiff demands that the defendant returns a thing that belongs to the plaintiff. The plaintiff further sought an order to evict the defendants and his affiliates from the said property in dispute. Parliamentarian Rishad Baduddin has been further remanded as per an order by the Colombo Fort Magistrates Court. The former minister was ordered to be remanded until September 1st. Considering a request by the legal counsel appearing for the defendant, the court decided to hear the case on August 26th for the defense counsel to make submissions to the court. The subsequent 90-day detention order was obtained due to the need for further interrogations. Meanwhile, Rishad Baduddin's brother-in-law, who was arrested over the alleged sexual abuse of a girl, has been ordered to be released on bail by the Colombo Chief Magistrate. Former Western Province Governor Asad Salih has been remanded until 31st of August. The order was issued by the Colombo Chief Magistrates Court. Salih was in the custody of the Criminal Investigation Department under detention orders. The arrest was made over several controversial remarks Salih had made at a press conference with regard to a law of the country. The Bar Association of Sri Lanka has written to the Chief Justice on their concerns regarding the current pandemic situation in the country and its effects on the operation of the courts in the coming weeks. Accordingly, the association has made several suggestions on how to carry out the judicial processes in the coming few weeks, which will be a critical period on the local pandemic timeline. The letter addressed to the Chief Justice contains pointers and recommendations made by the association, including segmenting the court list into sessions and banning the public inside courts during sessions unless necessary. That was a look at the major events of how the law has worked in our land. We will now go into a short commercial break. Danindu will be back after the break.
Hello, my name is Sunil Abeyratne. I'm studying Tourism and Hospitality Management. My question is about the crimes related to e-commerce. What are the laws protecting the safe commercial practices online?
Welcome back to Law, Land and Liberty. We are in conversation with Dr. Sunil Abeyratne. We covered a few areas, a few tense areas, primarily the fundamental law within the country that governs cyberspace and cybercrime, and then to social media and general online activities. Now, Doctor, our next priority is going to be another key focus. Now, you touched on fraud, and we really made a few references to this, and I believe there's an Electronic Transactions Act also within the country. This commercial aspect, the e-commerce aspect, a huge volatile area that can be misused by people, when things of monetary value are involved, that becomes a tense area. And like when we are looking at the future, a lot of these transactions are to happen online. Firstly, give us an understanding, Doctor, of how e-commerce is governed within the law within this country.
Now, once again, we have to identify what is electronic commerce. Now, earlier we had traditional commerce. Even during Vasco da Gama's time, the Ferdinand Magellan's time, also they had international trade and commerce. Today that we used electronic medium to carry the commercial activities. So that's why we call these commercial activities as electronic commerce. When you take this electronic commerce, again, we have to understand the nature and behavior of this electronic commerce. For that, there must be proper legal recognition. Now take what is document. Now the documents, most of the documents are in electronic form. Whether there is a legal recognition of this electronic document. If there is no such recognition, then we can't use electronic mediums to carry electronic commerce. So when you look at Section 3456 of E-Transactions Act in Sri Lanka, following ancestral model law on electronic commerce and electronic signatures, we have recognized electronic documents, electronic records, electronic communications and data messages as the legally recognized electronic records. Then the next area is if there is a document, then what is the authentication? So we know that if it is a paper-based document, we can place our manual signature. Now, if it is in electronic form, so we can't do it. Either we have to place digital signature or electronic signature. Then there must be legal recognition for this digital signature or electronic signature. It's an international requirement when you look at model law, even under UN Convention. So when you take Section 7 of E-Transactions Act, it's covered, that requirement is covered. Our Section 7 recognized electronic signatures. Electronic signatures means digital signatures also covered under that. The main requirement of the signature is that we must be in a position to identify the signatory who placed that electronic signature.
It should be unique to that person.
Unique to that person. In addition to that, we must be in a position to explain the intention of the signatory. Considering all the circumstances and additional evidence we have to establish. Then cyber security will play a vital role in that. The three pillars under cyber security, when you when you take legal recognition for that we can say it is confidentiality, integrity, and retrievability.
Okay.
If we don't have confidentiality, integrity, or retrievability, the people will not use electronic medium or online transaction.
Exactly.
To fulfill these three requirements, we have this provision under Section 7.
Okay.
So when you look at basic provisions under E-Transactions Act, we have followed this international, the model laws and the convention. We have already done our framework, but still that we can see some loopholes that we can cover and we can go ahead. But our basic document is available. Mm-hmm. Now it is high time to bring some rules and regulations to give the additional support to this framework and to proceed. And when you take electronic fund transferring, it also comes under these e-transactions. Yeah. Now take example electronic banking. In addition to that, we have that Payment Settlement Act as well. Then the latest development is cryptocurrency. There is the monitoring body. So we have to go a long way. Mm-hmm. Still that we are trying to entering into electronic commerce.
Yeah.
But other countries have gone a long way. But anyway, that if we can't do this within very short period, we will lose our international market. Today, everything is electronic or digitized. Yeah. Now, that I think all have realized during this COVID pandemic period. Now, without using ATM machines or some electronic that fund transferring or that without using websites, it has come to the level that we can't live in this country.
Exactly. Doctor, a very important point that you touched there. But we need to address this aspect also now. When it comes to following a money trail, if it is offline, maybe the evidence is literally tangible. But when it's online, let's leave the international aspect out of this and let's just consider if it's within our soil, within Sri Lankan soil. Does following things like money trails, investigation, the capacity of an individual to disclose their funds or how the funds come, what is the law there, Doctor? Like how is that governed?
As I explained you earlier, we can't sit down. We have everything covered under E-Transactions Act. Yeah. It is only one document. Yeah. It's only framework, as I explained you earlier. Mm-hmm. Now that is why under Section 23 of E-Transactions Act at the moment, we have removed certain subject areas. Now take example, we can't have electronic bills of exchange. It has been removed. Then we can't write electronic transfers, deeds. We can't write electronic gifts. We can't make electronic trust. So likewise, there's a long list. So this is one reason. Until we fulfill our infrastructure, that means other laws. There are lots of other laws must be involved in that. Take example, consumer protection. Exactly. It's one other area that seriously we have to think about that. Data protection, as I explained you earlier, and some criminal offences. Until we fulfill these requirements, we can't allow the people to apply these excluded subjects also under E-Transactions Act.
Okay. Doctor, just continue your line of thought there, Doctor. I want to touch on this aspect of transparency also. Is there a requirement when engaging in electronic commerce, when transferring funds between one another? What are the requirements for transparency? Is there a legal requirement maybe for banks or financial institutions to disclose certain information or to protect certain information when it comes to the cyberspace?
Now, when you take electronic fund transferring through that, say that banks and other institutions, that monitoring mechanism is there. Okay. It may be online or offline. Mm-hmm. So otherwise, that there will be lots of black currencies. Exactly. Will be exchanged. We have to stop that. Mm-hmm. So there must be other financial rules and regulations, laws must be there.
Mm-hmm. In that instance, Doctor, is it still the police that get involved in this kind of, when it comes to e-commercial activities, or is there other authorities, other institutions, other acts, maybe other laws that have been empowered to deal with this?
No, we have certain other acts. Take example, settlement of that Payment Settlement Act is there. Then Payment Device Fraud Act, the provisions are there. So like various acts are there, but my personal view is these acts are not enough to carry that electronic fund transfer successfully that compared to most of the other countries.
Yeah.
So they have introduced various that type of the laws and other regulations and mechanism that we have to follow, that how these other countries they carry this international fund transferring, electronic fund transferring successfully.
Yeah.
So based on that, we have to develop that area. This is a completely different area.
Yeah. Doctor, in this segment itself, I want to touch on this bit of a criminal aspect of people who try to show them as someone else online, who try to become imposters online. What sort of, because when it comes to e-commerce, when it comes to transactions, when it comes to any sort of interaction online, when you don't see the other person, when there is no physical or tangible way of recognizing, as we spoke a bit about authorization, the capacity for an individual to appear as someone else is still there. And there's a dangerous element to it. As a fraudulent sort of presence online, what sort of laws are available, Doctor?
At the moment, impersonation is a criminal offense under the penal code. Now, we must keep in mind, we can't introduce that offences relevant to computer-based offences through Parliament, because we can identify the unique offences.
Yeah.
Other offences, of course, first of all, we have to find out whether that similar offences are available in other statutes, including penal code. Now, impersonation is a criminal offence.
True.
In addition to that, as you said, if we can introduce one offence called that computer fraud, then we can give additional support.
Okay. When speaking of fraud specifically, Doctor, I just clarify as a last question within this segment, I want to ask you, fraud, identification of fraud, you said it's not within the law as of now, fraud completely directly relevant to e-commerce and commercial activities. What is the first step that we should take in that process in identifying this? Because even last week we spoke about commercial arbitration, and arbitration might be the biggest thing. And if we are to go there, we should be able to conduct ourselves virtually, even hear cases virtually, make it more fast-tracked. And that will be available on virtual platforms. So our cyber law, whatever governs the cyberspace, should be strong. What are the first steps that should be taken, Doctor? Is it just fraud that we need to identify, or is there some other step that you believe in?
Section 7, as I explained you earlier, it is subjective.
Okay.
Because case by case, we have to decide. So that is why Section 7 also says, considering all the circumstances and additional evidence. Now, sometimes typing our name at the bottom of the document can be considered as electronic signature.
Okay.
But sometimes, considering the value of the transaction and seriousness of the transaction, sometimes it is not enough. Then you need the encrypted signature. Likewise, sometimes you have to get the assistance of the service provider.
True.
The independent party will provide digital signature. Okay. That depend on the circumstances and the situation. That means the additional evidence we have to satisfy.
Okay.
In addition to that, we must have the good forensic labs. That is another important area. Now take example Singapore. They have the fine labs. I think our country is also developing that area. This is another area. Then the forensic issues will be a totally different area that we have to develop.
All right. Doctor, we'll take a very short break, and I want to talk about the international elements and international cybercrime as a whole. Let's take a very short break. Stay with us on Law, Land and Liberty.
Hello, my name is Mahel Sri and I'm a law student. My question is about the international crime related to cyberspace. Can justice be delivered for cybercrimes committed internationally?
Welcome back to Law, Land and Liberty. We are in conversation with Dr. Sunil Abeyratne. Doctor, on our last segment, I want to touch on the international crime aspect when it comes to cyberspace and how justice can be delivered in those scenarios. Now, a very brief question there that would be on how, if there is a criminal act done within another country or within another show. When it comes, we have witnessed issues when it comes to pornographic rings that have happened within other countries that are related to individuals, that crime has been committed against an individual within this country. Just iron out the details there, Doctor.
When you take Section 2 of Computer Crime Act, it's an international jurisdiction. If the victim or the accused or the device used to commit that crime or the affected device is available in Sri Lanka or outside Sri Lanka, it comes under this act. If a person commit any offence outside Sri Lanka, also covered under Part 3 of Computer Crime Act.
Yeah.
Now we have when you look at provisions under Section 3 of Computer Crime Act, that we have covered international cooperation to carry investigations relevant to computer crime. The mutual assistance is there. In addition to that, now we have Budapest Convention, because we are a member of Cybercrime Convention. So we can use this. We can exchange that information. We can exchange experts' knowledge and the other assistance.
Doctor, in that scenario, the most initial question that comes to mind is it multilateral agreements that will govern issues pertaining to cyber law as well? Because we see this happening in extradition law, where if an individual is to be sent out based on a case, a subpoena from a certain court in another country, extradition laws primarily depend on multilateral agreements. Is that the same thing when it comes to cyberspace, cyber laws?
Now, when you take Part 3 of Computer Crime Act, extradition law also included.
Okay.
It's offences under Computer Crime Act are the offences under extradition law as well. It's covered now.
Okay. In moving to, again, that issue of identifying victims, identifying criminals or people that did an offence while staying in another country, Doctor, just iron out the process. How will those people be brought to justice? If let's say an individual's photographs are leaked without their consent, and that individual is in another country and that the victim is within Sri Lanka, can those people be brought to justice?
Now we can apply two acts available in the country. One is 2002, that International Cooperation of the Criminal Matters. That act is covers under Part 3. Then other areas extradition law.
Okay. So those are the primary. Those are the primary laws. Any other international agreement that we have come into, Doctor, that you would like to highlight in this scenario that deals with international crime, that subsequently we can have sort of justice dealing with this? Because the question that many people would have is, okay, if the crime is committed outside the shores, then it's out of our hands. We have no control over it. Is that what happens when it comes to law?
No, at the moment, all citizens must aware that we are member of Budapest Convention. Cybercrime Convention is a very strong convention.
Okay.
So we can get the assistance of other member countries. Member countries in the sense, most of the European countries and most of the developed countries and developing countries are members of this convention.
Mm-hmm.
So then it is easy to exchange suspects with these countries, because when you take extradition law, most of the countries apply same extradition law. But I can't see any barrier. Only issue is we must have more experts in the country relevant to this area. The police department must have the proper training for this. The police officers now that they must enter into scientific investigations. It's high time now.
All right. As a final question, Doctor, before we end our discussion, in moving to a more collaborative approach to international to addressing cyberspace internationally, what are the first few steps that we should be taking in terms of considering the vacuums within the country for international law? Immediately,
we have to go through Cybercrime Convention, the offences specified under Cybercrime Convention, and to bring the required amendments to our Computer Crime Act. Then the next area is the education. Even my suggestion is at least to give a couple of pages to the subject information technologies is done by that O-level students. Yeah. From the beginning, then they can understand what is computer crime, and if they misuse computers and systems, what are the consequences? That is number 2. Third is, it is high time to educate law enforcement bodies properly.
Okay. Doctor, I think that's a very good position. We really covered quite a few areas pertaining to a very thematic and very contemporary subject, I should say. Thank you so much for joining us, Dr. Sunil Abeyratne, who recently received his PhD from the Columbia University and is one of the first pioneers within this industry. Thank you so much, Doctor, for taking the time to join us.
Thank you.
All right. The discussion tonight shed a lot of light on the legal frameworks governing the cyberspace. It is important to bear in mind the scope of cyberspace and its ever-expanding areas of regulation. A renowned academic in the field of cyber law is Harvard professor Lawrence Lessig. Amongst his many academic publications was his writings in the Harvard Law Review, where he once stated, "At the center of the lesson about cyberspace is an understanding about the place of law. We face a choice about life in cyberspace, a choice about whether the values embedded there will be the values we want. The code of that space has the power to constitute the values that resonate with our tradition. It also has the power to constitute values inconsistent with our tradition." In looking at the future of cyber legislature, these thoughts become very important. That is all from us here at Law, Land and Liberty. Join us again next week as we bring to you another legal topic and break it down. I'm Danidhu Tanwasa. Have a great night.